Hello everyone, I'm Anu, an engineer and a law graduate, and I welcome you to my channel where law meets logic and learning becomes easy. If you're a law student preparing for your semester exams or just someone passionate about understanding how laws shape our world, you're in the right place. In this series, I'll be covering important questions from each subject, semester-wise, explained in simple, structured, and student-friendly language. Today, we're diving into one of the most critical subjects, environmental law, where we'll explore the meaning of environment and pollution, key legislation like the Environment Protection Act, and even international treaties that impact us all. So make sure to subscribe, grab your notes, and let's decode the law, one topic at a time. What we will cover are: what is the meaning and definition of environment and pollution, and what are their types, sources, and consequences? What are the constitutional provisions in India related to environmental protection, and is it considered a fundamental right? How does the Criminal Procedure Code, CrPC, contribute to environmental protection and enforcement? What is the role of public interest litigation, PIL, in protecting the environment in India? What are the key features and provisions of the Environment Protection Act, 1986? What are the main provisions of the Indian Forest Act, 1927, regarding forest conservation and management? What does the Air Prevention and Control of Pollution Act, 1981, provide for controlling air pollution? How does the Water Prevention and Control of Pollution Act, 1974, help in regulating water pollution? What is the structure, power, and function of the National Green Tribunal, NGT? What are the major international treaties and agreements related to environmental protection, and what is India's role in them? So let's start. 1. Meaning and definition of environment and pollution. Types, sources, consequences, and Indian philosophy of environmental protection. Introduction. Environmental protection is not a new concept for India. Historically and culturally, the environment has been revered. However, modern industrial growth, population expansion, and resource exploitation have necessitated a legal framework to define and protect the environment. Understanding what constitutes environment and pollution is essential to build regulatory and judicial mechanisms aimed at protecting ecosystems and human health. Legal definitions in Indian law. Environment, defined under Section 2A of the Environment Protection Act, 1986. Environment includes water, air, and land, and the interrelationship which exists among and between water, air, and land, and human beings, other living creatures, plants, microorganisms, and property. This definition is intentionally inclusive and interdisciplinary, recognizing the complex interdependence of various components. It aligns with the ecosystem approach promoted globally by the UNEP and IPCC. Pollution. Under Section 2(c) of the same Act, pollution means the presence in the environment of any environmental pollutant. And Section 2(b) defines environmental pollutant as any solid, liquid, or gaseous substance present in such concentration as may be or tend to be injurious to environment. These definitions provide statutory authority to government bodies like central and state pollution control boards, CPCB, SPCB, to act upon environmental harm. 3. Types of pollution. 1. Air pollution. Air pollution involves the release of harmful pollutants like sulfur dioxide, SO2, nitrogen oxides, NOx, carbon monoxide, CO, particulate matter, PM2.5, PM10 into the atmosphere. Legal framework. The Air Prevention and Control of Pollution Act, 1981. Major sources: vehicular emissions, thermal power plants, biomass burning. Consequences: respiratory diseases, acid rain, climate change. Landmark case: Maitse MC Mehta v. Union of India, vehicular pollution case. The Supreme Court ordered a phase-out of diesel vehicles in Delhi and mandated CNG for public transport. 2. Water pollution. Contamination of water bodies by sewage, industrial effluents, or agricultural runoff. Legal framework. Water Prevention and Control of Pollution Act, 1974. Consequent. Waterborne diseases. Aquatic ecosystem destruction. Landmark case. Missy Mehta v. Union of India, Ganga pollution case. Supreme Court ordered closure of tanneries and industries that were directly polluting the Ganga. 3. Noise pollution. Unwanted sound that disrupts the balance of life. Legal regulation. Noise pollution, regulation and control rules, 2000. Sources: traffic, construction, loudspeakers, industrial operations. Important case. À school. Y en lo de l'année sonique offre doté. The Supreme Court banned use of loudspeakers between 10 p.m. to 6 a.m., except in cases of emergencies. 4. Soil pollution. Degradation of land due to chemicals, deforestation, and dumping of non-degradable waste. Leads to reduced agricultural yield, contamination of groundwater. 5. Termolerradiación poluyente. Thermal pollution. Waste heat from power plants raises temperature of water bodies, affecting marine life. Radioactive pollution caused by leakage or improper disposal of nuclear waste. 4. Of sources of pollution, detailed analysis. Source pollutants impact. Industrial emissions, SO2, NOx, VOCs, air and water pollution, acid rain. Vehicle CO, PM2.5, NOx, respiratory issues, smog. Agricultural runoff nitrates, phosphates, eutrophication, groundwater contamination. Municipal waste, organic, inorganic waste, plastics, soil and water pollution, methane from landfills. Thermal plants, heated water, fly ash, thermal pollution, toxic residues. Sí, consecuencias de la polución, científico y sociolegal dimensiones. Human health. According to Lancet 2020, 2.5 million Indians die annually due to air pollution. The WHO declared air pollution as a public health emergency. Environmental collapse. Loss of biodiversity, extinction of species, coral bleaching. Climate change. Global warming, extreme weather events, glacial melt, rising sea levels. Legal conflicts. Pills against dams, industrial projects, and mining due to environmental and displacement concerns. Económico impacto. Estimated loss due to pollution in India is over 5% of GDP, World Bank report. 6. Indian philosophy and cultural approaches to environmental protection. Vedic ecology. The Rig Veda sees Earth, Prithvi, as a nurturing mother. Yajurveda encourages sustainable use. Do not harm the trees and rivers. 2. Upanishadic thought. All life is interconnected. Vasudhaiva Kutumbakam. The world is one family. Karma and Dharma include responsabilidad tu naturaleza. 3. Jainism and environmental ethics. Strong focus on ahimsa, non-violence toward every organism. Followers carry brooms to avoid harming insects. 4. Buddhism. Principle of dependent origination suggests that harming nature harms oneself. 5. Modern Indian environmental movements inspired by culture. Chipko movement, 1973. Villagers, mostly women, hung trees to prevent deforestation. Narmada Bachao Andolan, protest against displacement from dams, rooted in Gandhian environmental ethics. Silent Valley movement, Kerala, saved rich biodiversity from hydroelectric project. V. Important judicial doctrines y ambientales principales. Doctrine, explanation, landmark case. Polluter pays principle. Polluters should bear the cost of damage. Vellore Citizens Welfare Forum versus Union of India. Precautionary principle. Prevent environmental degradation even in the absence of full scientific certainty. AP Pollution Control Board versus Professor M.V. Naidu. Sustainable development. Balance between development and environmental protection. Narmada Bachao Andolan versus Union of India. Intergenerational equity obligation to preserve resources for future generations. Indian Council for Enviro Legal Action versus Union of India. Pale Eel Role of international treaties. Even though this is elaborated more in question 10, it's worth noting. Stockholm Declaration, 1972, marked the beginning of international environmental law. Rio Summit, 1992, introduced Agenda 21, Oath Charter, CBD. Paris Agreement, 2015, India à Comité à des Nationales Déterminées, NDC. X. Scholarly Commentary. Professor Leela Krishnan calls Indian environmental law a hybrid legal system combining civil, criminal, and constitutional remedies. Amartya Sen emphasizes that sustainable development is essential for social justice. X. Conclusión. Pollution is not merely an environmental issue, it's a constitutional, human rights, and developmental challenge. The Indian legal system, through expansive interpretations of Article 21, various statutes, and judicial activism, has taken significant steps. But true change requires behavioral transformation, community participation, and enforcement of existing laws. India's ancient ecological wisdom, if combined with modern law and science, can provide a sustainable path forward. 2. Constitutional provisions relating to protection of the environment. Is environmental protection a fundamental right in India? I. Introduction. The Indian Constitution, though silent at the time of its adoption in 1950 on environmental issues, has since evolved into a powerful tool for ecological governance. Over the years, judicial interpretations and legislative amendments have ensured that environmental protection is not only a statutory obligation, but also a constitutional mandate, particularly through the expansion of Article 21, which guarantees the right to life. This answer will examine the constitutional provisions, interpretive expansions by the judiciary, directive principles, fundamental duties, and how these interact to establish environmental protection as a constitutional and fundamental right in India. So, histórico background and evolución. When the Constitution was adopted in 1950, environmental concerns were minimal. However, with increasing industrialization, urbanization, and ecological degradation, the 42nd Constitutional Amendment, 1976, marked a pivotal moment by inserting explicit environmental duties and obligations into the Constitution. 3. Relevant constitutional provisions. A. Article 21, Right to Life. No person shall be deprived of his life or personal liberty, except according to procedure established by law. The Supreme Court has expansively interpreted life to include the right to live in a clean and healthy environment, thereby implicitly incorporating environmental protection as a fundamental right. Key cases: Subhash Kumar v. State of Bihar, 1991. The court declared, right to life includes the right of enjoyment of pollution-free water and air for full enjoyment of life. MC Mehta versus Union of India, Oleum Gas Leak Case, 1987, established the principle of absolute liability for hazardous industries. The right to a healthy environment was reaffirmed as part of Article 21. Virender Gaud vs. State of Haryana, 1995. Environmental, ecological, air, water pollution, etc. should be regarded as amounting to a violation of Article 21. T.N. Godavarman Tirumulpad versus Union of India, 1996. Court issued sweeping directions for forest conservation under the broader umbrella of Article 21. B. Article 48A. Directive Principles of State Policy. The state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. Inserted by the 42nd Amendment. While not justiciable, it provides policy direction and serves as a guide for legislative and judicial actions. C. Article 51A G. Fundamental Duties. It shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. Also inserted by the 42nd Amendment. Encourages citizen participation in environmental protection. Though not enforceable in a court of law directly, Courts have relied on this article to impose responsibilities on individuals and corporations to act in eco-conscious ways. Case reference. In Ames Students Union versus Ames 2001, the Supreme Court cited Article 51A(g) to stress the role of youth and students in environmental conservation. D. Article 14, Right to Equality. Environmental justice must be equally available to all. Arbitrary state action that disproportionately affects a community's right to clean environment can be challenged under Article 14. Case. Bangalore Medical Trust versus B.S. Mudappa, 1991. Conversion of a park into a hospital site was struck down as arbitrary and violative of Article 14. E. Article 19(1)(g), right to practice any profession. This fundamental right is subject to reasonable restrictions in the interest of the general public. Environmental laws often restrict industries and professions for public health. Case. MC Mehta versus Union of India. Tanneries Case, 1996. Closure of polluting tanneries was upheld despite arguments about loss of livelihood. F. Artículo 32. Constitucional Remedio. Provides citizens the right to move the Supreme Court directly for enforcement of fundamental rights, including environmental rights under Article 21. Public Interest Litigation, PIL, under Article 32 has been a crucial vehicle for environmental activism. 4. Interrelationship between fundamental rights and directive principles. Although directive principles, Part 4, are non-justiciable, the judiciary has harmonized them with Part 3, fundamental rights, as held in Minerva Mills v. Union of India, 1980. Fundamental rights and directive principles are complementary and together constitute the core of the Constitution. Therefore, Articles 48A and 51AG strengthen the enforceability of Article 21 by enabling broader interpretations. Fine, judicia principios emergen de la interpretación constitucional. A. Public Trust Doctrine. Government acts as a trustee of natural resources for public use. Prevents the state from transferring common resources like forests, rivers, to private entities. Case. NC Mehta versus Kamal Nath, 1997. Court prevented a hotel project from encroaching a riverbed. B. Precautionary principle. Prevents harm to the environment even when scientific certainty is lacking. C. Polluter pays principle. Polluters are liable for environmental harm and for remediation. D. Sustainable development. Promotes long-term ecological and economic balance. C. Role of the judiciary in making environmental protection a fundamental right. E. Pro environmento jurisprudencia. The Indian judiciary has not limited itself to interpreting laws, but has often filled legislative voids, prescribed standards, and even monitored compliance. Case study. Villars Citizens Welfare Forum versus Union of India, 1996. The court held that Article 21 includes the right to clean water. Enforced the precautionary principle and polluter pays principle. Directed pollution control mechanisms for tanneries in Tamil Nadu. B. PIL and social action litigation. India's judiciary has democratized access to environmental justice by allowing PILs, which can be filed by any concerned citizen under Articles 32 or 226. This approach has made judicial redress more accessible to marginalized communities, tribal groups, and the poor, who are often the first victims of environmental degradation. 5. Comparativa constitucional perspectiva. USA. No express right to environment in the U.S. Constitution, but courts protected under statutes like NEPA, 1969. South Africa. Express right under Section 24 of its Constitution. Norway and France explicitly mention environmental protection in constitutional texts. India's approach is unique in relying on judicial creativity and expansion of Article 21, combined with directive principles and fundamental duties. V. Challenges and criticisms. 1. Enforcement deficit. Despite constitutional provisions, implementation by executive agencies is weak. 2. Judicial overreach. Critics argue that excessive judicial activism may blur the separation of powers. 3. De ley injustice. Environmental litigation can span years, reducing its deterrent effect. Recommendations. Codification of environmental rights into an enforceable fundamental right explicitly. Strengthening regulatory authorities like CPCB, SPCBs with autonomy and accountability. Environmental courts at district levels for speedy disposal. Public awareness and environmental education, as mandated under Article 51A(g). Conclusión. Environmental protection in India is no longer merely a policy goal or statutory aspiration. It is now a constitutional imperative. Through the expansive interpretation of Article 21, in harmony with Articles 48A and 51AG, the judiciary has enshrined the right to a clean and healthy environment as an inseparable part of the right to life. While significant jurisprudence and policy frameworks exist, the next step lies in implementation, enforcement, and implementation, and mass awareness. Do like and subscribe for more videos, and don't forget to check out the other videos on this channel as well. In the next part, Part 2, we will continue with the remaining important topics. How does the Criminal Procedure Code, CrPC, contribute to environmental protection and enforcement? What is the role of public interest litigation, PIL, in protecting the environment in India? Please like, share, and subscribe. Thank you for watching.